Good morning, I'm Victor Ortega, lawyer of Strength and Power Company, and I'm here recording this video to defend the interests of my client in front of the reclamations of Klugewagen, reclamations that I totally consider disproportionate and unjustified. Well, first let's analyze the case briefly. The CEO of the company that I defend and the procurement manager of Klugewagen closed a sales agreement under which my client had to deliver 20,000 tons of steel plate. It's important to mention that both persons are empowered to make the contract, so it's valid and binding for both parties. In the sales agreement, it's also provided an arbitration clause for potential and future disputes, as is the case, which sit in Tokyo and 3 arbitrators, administered by Japanese Center of International Arbitration, and the procedural aspects are governed by Brazilian law. In the case, 4 days before the delivery, my client's drivers became terribly ill and couldn't make the delivery. At this moment, Klugewagen had not paid yet. That's under Article 58 of CESG. Klugewagen is not obligated to pay until they have the opportunity to inspect the goods. So that's not important, but they must pay once the goods are delivered, as we hope that could happen in the future. The delivery, according to the sales agreement, had to be done by DPU, that means delivered at place unloaded, established in Incoterms 2020. Under this term, the seller bears all risk involved in bringing the goods to the destination or the agreed point. In this case, to the destination, to the place of Klugewagen. Taking this into account, could seem that my client have to take responsibility, but it's not like that if we observe the Article 79 of CESG. Under the 79.1, a party will not be liable for failure to comply if it's due to an impediment beyond his control and it couldn't reasonably be expected at the time of holding the contract. Also, under the 79.4, the party that fails to comply has to notify the other with a reasonable period of time. Okay, this, with our case and the article in the hand, it's clear that my client couldn't foresee this serious matter as an influenza pandemic, which is a case of measure force that prevented the compliance regardless of my client's will and totally out of his control. It's also obvious that my client notified the other party with a reasonable period of time just when he realized about the problem, because 4 days when the goods are already in the port of Shanghai, it's a well in advance communication. Finally, about the Article 79 in the point 5 says that the article wouldn't prevent the other party of exercise any other right different of the compensation of damages. So, reading this carefully, is the wording of the article is preventing the claim of the compensation for damages. So, if the requirements that I have already demonstrated occurs, it couldn't be paid. It's like not have sense. Sorry, I'm a little bit nervous and I have no time because I thought that it's until 12:30 and it's until 11:30, so I'm being too much fast. Sorry for that. I hope I understand. Next, we have to take into account the Article 74 of CESG, where it's established that damages of the breach of contract are meant to cover the loss suffered and the gain the other party lost due to the breach. However, the damages cannot exceed what the breaching party could have reasonably foreseen at the time of signing the contract. This means that only losses directly related to the breach of the contract can be considered, and these losses must have been foreseeable at the moment of signing the contract. So, considering that Klugewagen can't claim any damage due to Article 79, it doesn't make sense that claim for legal fees, just as it made no sense to mention it in the terms of reference, because they are not a direct loss caused by the delay in delivery and they are not foreseeable at the moment of signing the contract. Furthermore, it would be a claim that exceeds the loss suffered and the loss of potential profits. So it's not foreseen in the legal text, in the law. So it's for that we consider that it's totally inappropriate and totally exceed the claim that the law allows to make to Klugewagen. So, although Nidroid principles and the Article 27 of Brazilian arbitration law allows to claim the legal fees, in this case it's totally inappropriate. Besides, my client didn't agree with the terms of reference. Following, the New York Convention on Arbitration ensures that arbitral awards are enforceable, as both Japan and Brazil are signatories. Under Brazilian arbitration law, procedural aspects, including the composition of a free arbitration tribunal, are governed by the parties' agreements. So my client is ready to contest the recognition of the award if it involves unjustified damages or excessive claims. In conclusion, my client should not be held fully liable due to the force majeure event that prevented the delivery. Payment was not due because of non-delivery, and any damages must be proven without including contingency fees. S&P actions were reasonable under the circumstances, and the tribunal should dismiss Klugevagen's excessive claims, awarding a fair decision based on the facts and the international and Brazilian law.